Welcome to the Seattle Investors Club podcast with Julie Clark and Joe Bauer, where we share the nuts and bolts of real estate investing from our 20-plus years in the industry. Sit back, relax, listen, and immediately take action. Are you ready? Here we go.
Welcome to the Seattle Investors Club podcast, where we talk about the nuts and bolts of real estate investing. My name is Joe Bauer, and I'm here with my co-host, Julie Clark. Julie, how are you doing today?
I'm good. What's going on? Where are you at?
I'm in beautiful Fresno right now.
The reason why we asked Joe where he's at is because Joe is like on the road full time for like what, a year or who knows? Open-ended. And he's riding up in his van, which you guys can see if you follow Facebook. Look up is it called The Fantastic Life, right?
There you go.
Fantastic Life. It's pretty awesome. Pretty awesome stuff and fun to follow along. So we never really know where Joe is until he tells us. So you're in Fresno. I don't know if I would have predicted that as your answer today.
Well, Fresno, because I've got to go hit the airport tomorrow to come fly back and hang out with you for the weekend. So.
Oh, hey, that's right. Seattle Investors Club meeting this weekend, everybody. Come join us. It's going to be a good topic, talking about Title and Escrow 101. You think you might know all the answers, but I promise you don't. And the eloquent mystery guest, because I'm not sure if we're allowed to say his name or not. What do we call him on that podcast?
The dude.
The dude will be joining us. If you're listening, this is probably after the dude has joined us. So I hope you enjoyed it. How about that? Well, over here up in the Seattle area, at least for us, it is the last week of school. As some of you may know, I have twin third grade girls. So pretty exciting stuff. Wrapping up third grade tomorrow. They get out at 10:30 a.m. But what's even more exciting is that we're all dropping the kids off at about 8:15, and then a bunch of moms are headed back over to my house, and we are going to drink mimosas and eat quiche until we have to pick them up at 10:30 in the morning tomorrow.
Yeah.
Yep, that's how we throw it down over here. We don't waste any time. We party in the morning as needed, so got to kick it off right. That's how we have to deal with it, because we have all our little monsters coming home for the summer. So, woof, dang. Well, I look forward to seeing you. I guess that would be not tomorrow, but the next day on Saturday, Joe. Safe travels.
Yeah, and if anybody has not been to Sequoia National Park, I highly recommend it. It's one of my favorites so far. Really cool.
That was where you guys were just at, right?
Yep, really big trees, like redwoods,
awesome.
But not redwoods.
Spectacular.
Yeah.
Well, speaking of kids, and I don't know, I'm trying to transition. I'm trying to find a good transition to announce our rock star. Should we call her a super lawyer? You let us know. Synthia, are you there? Synthia Melton.
I am here. I guess you could call me a super lawyer, because I have been on the super lawyers list for the last 3 years.
Heck
but
yeah.
Hey.
Hey.
Yeah. So, well, thank you guys so much for having me on. This is exciting. I'm happy to chat with you today.
I've been on a list for the last 3 years, but we don't want to talk about what list that is.
The super lawyers,
not on any list I don't know about. Yeah, super list.
Super
lawyer, awesome.
It's one of those weird lists. It's like 3% of attorneys, you have to be under the age of 40. There's all these requirements, but your peers vote you in. So it's kind of cool.
It is cool. And that's why you're joining us today, because we know that you've got all the nuggets, a lot of nuggets that us real estate investors, not only investors, but agent investors, contractors, landlords, all that stuff. Today's going to be a good deep dive into, I guess we're going to call it contract disputes, but knowing us, we'll get off tangent and we'll see what else comes up. Sound good to you guys?
Yeah. Sounds good.
Definitely.
Sounds good. Well, Joe, kick us off.
Cool. Well, Synthia, we are excited to have you on the show. Thank you so much for making the time. And we'd love to hear, what your background is and why you became a real estate attorney.
Well, tell us the name of your firm first so we get that out there so everybody can look you up while they're listening.
So my firm is called Dimension Law Group, and that's Dimension Law Group. And we are located, our main office is in Tacoma, Washington, so South Center, pretty central to, Pearson King and all the courts that we need to go to. But we are an all-female owned and ran firm, and it's pretty cool. I love our firm. I have a partner,
Awesome.
Julie Martinello, and we do primarily real estate, business, estate planning, and probate. And we are lucky enough to have just some incredible clients. Most of our clients are real estate investors, whether it's commercial or residential, sort of small to mid-size. So we're able to help them really, just being able to sort of set up their business structures, whether it's corporations, LLCs, whatever it is, real estate contracts, disputes, a lot of landlord-tenant eviction work as well, and then helping plan for their future. And if you've got all these properties, if you're buy and hold, what are you going to do with them? Sort of some tax planning about, passing it on to your kids, protecting it in trust, and then probate as well.
That's awesome.
Yeah,
We all need that. Pretty much everything you said is everything that we all need. No doubt about that. And I think you guys all know that everybody, needs to have a great real estate attorney on their team. And one that specializes in working with real estate investors is an extra bonus on top for sure. So,
right. And, it is, especially if you're an investor, I think the importance of having a team in place, not just your attorney, but having a good CPA, having a good, insurance agent, good title and escrow person, just having all these members of your team are extremely important. And so I personally am not just an attorney, I also own and run a business. And so I know the importance of having a team. I know we have an amazing CPA that we work with that I go to a lot for advice. And then I'm also a landlord. And so I have, my husband and I have some rental properties, and I do a lot of landlord advocacy work. I'm really passionate about that. And so I sit on the board for the Rental Housing Association of Washington, RHA. I'm currently vice president, and then I sit on the education committee and the forums committee. So it's really cool to be, personally invested in this because I'm passionate about it personally, but then it's nice to be able to do it as my day job.
heck yeah. That's awesome. So how did you, when you went to law school, let me ask you, are you a Husky?
I am not. I went to Seattle U.
Oh, you went to Seattle U.
Actually,
Awesome.
I did. Everybody in my firm actually just worked out that way, went to Seattle U. Most of the attorneys, one of our businesses, me and a couple of our business partners, is we rent out spaces in our office space to other attorneys and who do practice in different practice areas, so we can sort of create a comprehensive firm, but everybody still maintains their own spaces and own offices. Most of them have all gone to Seattle U. So nice little family. We love Seattle U.
My cousin is a contracts attorney who went to Seattle U. We'll have to talk later about if you guys know each other. But the reason I asked is because if you were a Husky, I was going to have to wrap up early because I'm a Cougar. Go Cougs.
Well, no worries. I actually, for undergrad, I went to Western in Bellingham. And, we're not sports school, so there's nothing to worry about there. But yeah, I went to Western, then I went to Seattle U. And actually, when I came out of law school, I was doing criminal defense and immigration defense. So I was doing a lot of felony work, and it was intense, to say the least. I was, in court literally day and night, in prisons and jails all day long. And so it was very stressful work, but it was really good because I was thrown into court with, people had been doing it 20, 30 years, and you just learn a lot. And so I think it's made me, having that court litigation experience has made me a better transactional attorney. And I still do litigation. Litigation is just going to court. I still am in court probably about an average of, once a week or so. But it just makes you more confident as a young attorney when you're dealing with some of this kind of, felony cases. We had a lot of robberies, sex offenses, some murders. So I learned a lot the first couple of years. And then I decided I don't want to do this for the rest of my life. So that's kind of how I made the transition to.
Did you have like a
real
bad,
estate.
did some crazy client or defendant change your mind or anything like that? Or were you just getting burnt out?
It was just really burnout. Because I started off just doing criminal defense. Then I went into criminal defense and immigration defense. So you're dealing with it at a state court level and federal court level. And the firm I was working for at that time, we had offices here in Seattle and in Yakima. So some mornings I'd be in Yakima and afternoons I'd be in Seattle. And it just was, it was really just burnout. And I stopped kind of feeling like I was really having an impact, I think, just especially with some of the federal laws. And so I started thinking seriously at that point about what do I want to do with the rest of my career as an attorney, because there's a lot of different things you can do. And my husband, his mom had been a landlord for a very long time. She still has rental properties. And so it was something he was always interested in. And at that point, I had still been doing a little bit of business law. And so I just decided I quit my job and I started my own firm and just started doing a bunch of business law. And then I partnered up with someone who was doing real estate work. And so now 5 years later, I can't imagine doing anything else. It's given me the confidence to, go out and for us to personally invest and become landlords. We're more buy and hold at this point. But I love it. I love the clients we have. I love real estate. There's just so many different little things you can do that are unique. And I'm always learning something new because, we as attorneys don't know everything. So now I can't see myself doing anything else. I really feel like I found what it is I was supposed to be doing within the law.
Wow. I think it's true that anybody who touches real estate in any way, whether you're a broker or a contractor or even the title people or attorneys like yourself, real estate is so fascinating and the opportunities are so big that if you are servicing anybody related or touching real estate in any way, you can't help but want to get in the game, right?
Right. And, I don't, right. No, I totally agree. And for me, I'm more of, I think I'm probably a little bit more risk averse than my husband, but, I needed to learn more about the industry and do that. And that's really what gave us the confidence to be able to start doing all this. And now I'm just like, okay, great. I know this information. And if I don't know it, then at least I know where to go and find it and educate myself.
And how fun to have a firm full of women, and just that is unique. I know for me, I love supporting you in that. I wouldn't call myself a woman's libber necessarily, but I do like that. There is some, I think, congratulations on that. That's totally awesome. And
well, thank you.
That's why we support you.
It's interesting because in our industry in real estate, especially in real estate law, there isn't very many women attorneys that I've come across, or at least definitely not all women firms. And so it's sort of a different dynamic. But, my partner, she has some real estate. She flipped her first property, then did a build. Our associate has flipped property. So we've got people that are personally interested in this stuff. And I think it makes for us just being better attorneys, because then you've got a little bit of this, you've got this passion that helps kind of fuel what you're doing in the daytime, and it makes you want to learn more and it keeps you interested in it.
Exactly.
And so it forces us to stay on top of, things when laws are changing, because they're constantly changing, and it is very hard to stay on top of it. Right now, for example, like a Seattle landlord, I don't even know I don't have any properties in Seattle that are rentals, but with how often things have changed, it's so hard to keep track of these things.
Right. Is that what you think as far as laws that are changing right now? Is that the one that is kind of the hot button or up for, being debated at the moment? Or Are there other topics that are hot right now?
Well, so that Seattle is definitely one that's ever changing, and we have to keep an eye out on Seattle. And so a lot of what we do through the Rental Housing Association, one of the reasons I'm personally a member is because it helps me stay on top of what the changing laws are. And, they send out emails and bulletins and things because I won't be able to keep up with all of them. But what's happening in Seattle is now you're seeing it kind of transfer to different cities. So,
Right.
Tacoma is working on a bunch of stuff that's going to be similar. I think they already have an inspection ordinance, but there's they put in instead of a 20-day notice to terminate, if you're going to do substantial rehab on a property, it's 90 days right now. That's in effect until September. So there's constant. It's really difficult, which is why I'm all about self-advocacy and self-education and really being involved or being part of groups or organizations where you can stay on top of this. Because for an average investor,
I got a good idea. You should start your own podcast or your own meetup. That's like a once a month check-in on the changing laws or what went into effect or what's pending, even if it's God, we would love for you to pop off like a video and share with Seattle Investors Club members. Hey, like once a month, an update. Hey guys, this is what's going on this month, or this is what changed this month, especially when it comes to the tenant landlord stuff, because you're right, it's hard to keep up with. And I think there is a need. People are so into buy and holds right now. I mean, like it is, they have just, that interest in the buy and hold thing has quadrupled in the last few months. It seems like everybody's, people are having trouble getting contractors, and I don't know, but that would be a really, really awesome for you. I know that you have some other things going on that are going to take up your time. Right?
I do have a little baby on the way, my first baby in the fall. So I'm sure that's going to keep us busy. But actually, we're working on just sort of a newsletter. We need to get better about blogging in our firm. But for now, before I do all that, I will just say, people can go, the RHA blog the Rental Housing Association blog is a good resource for staying on top of changing laws, because it's Washington, so it's not just City of Seattle. There is one other law that just, this is really going to kind of change things for my clients who buy at auction and foreclosed properties. And I'm sure, a number of your members buy at foreclosed properties, but it's called the Protecting Tenants Against Foreclosure Act. And this law was in place up until 2014 in December, and then it expired, and it just was repealed, and the president signed it back into law on May 24th. And what it is it basically says that a tenant in a foreclosed property, so this applies to banks, purchasers, REO, if you're buying a foreclosed property, they get 90 days notice before they have to vacate a property. And there's a whole bunch of other different pieces to that, because if a tenant is under a term lease that has not expired and it's a bona fide tenant, meaning it's not a family member of the previous owner, they're paying market rate, close to market rate rent. If you as the buyer are not moving into the property, then you have to give them the entire term of their lease. So the 90 days, they have to move out within 90 days. If there's certain exceptions they don't meet. So there's certain things that it's, below market rate. It's not a bona fide tenant. You're moving in personally. But it hasn't been a law for the last 3.5 years. So it's kind of made things easier for us. Washington State requires 60-day notices for, let's say, for example, if you buy at auction, the 60-day notice for a tenant to vacate would apply. But this is federal law. The 90-day rule is federal law, and it applies to all foreclosed properties that have tenants in it. So it's going to be something that we're actually going to be publishing a blog about. It's going to change how we do things a little bit.
Yeah, I mean, I think I always think as long as people know what the rules are, right? Then they can figure out how to play by the rules, right?
Exactly.
So, I mean, it just adds costs, right? And
it
maybe
does.
a little risk.
It adds cost, and it still doesn't take away your ability to negotiate with a tenant, do cash for keys or things like that. So it's not meant to scare people. Oh no, you can't buy foreclosed properties that have tenants in it. It's just know that you have to send out this notice, because if you don't, and you try to evict them or things like that, you won't be able to. You've got to give them the 90-day starts from when you send the notice, and it has to be proper notice. So there's all these little things that are constantly changing. So this is why it's important and sometimes it can be really overwhelming for your average investor and landlord. So important to have your team, your lawyers, accountants, things like that we talked about, but also important to self-advocate and stay educated.
Heck yeah, no doubt. Let's jump into contract disputes a little bit. That is super good info that you just laid out for us there. So we definitely want to hear from you, or give us a heads up when your blog comes out on that.
Yeah, definitely.
I actually haven't heard anybody actually say anything about that. I pray, as far as on all these forums, I haven't seen somebody mention that so much. I actually saw people talking about the 60-day notice, and nobody's recently without anybody talking about the 90-day notice.
Yeah, so it was just President Trump signed it into law on May 24th, and it takes effect 30 days from that date. So it'll be like June 24th is when they'll start. So it's going to be this month, and so people need to know about it, because we do have a lot of people that buy at auction,
right? A
lot of REO properties. But yeah, so I'll definitely keep you guys updated on that.
Awesome.
But contract disputes, that is a very wide area of possible things, because there's very many different types of contracts. I can tell you some of the most common ones that we see are there's a lot of contractor issues, a lot of issues that people, flippers have with their contractors. We do joint ventures, and sometimes you'll have that, but not so much. A lot of what we do with our clients is we try to help prepare them and, draft these contracts ahead of time so they can try to avoid litigation and avoid these issues. But what we see, unfortunately, is people will try to, investors they're savvy, they're always trying to be frugal, and so they might share contracts, and you're using a friend's contract, it may not apply to you. And so they usually arise when people, one, don't understand certain terms in the contract, or they don't really read what they're signing. So some of the common ones we're dealing with are, in the summer, we see this a lot more contractor lien issues, contractor disputes, joint ventures. For the most part, that works out pretty well because two people are in it and they have the same goal that they're working towards. What a joint venture basically is two individual parties entering into an agreement for one specific project. So a lot of times what you'll see is people who are, someone's bringing the money, someone's bringing the expertise. It might be an agent or something like that, where they're saying, I'm going to manage the contractors. I'm going to manage this flip for you. You're just putting up the money, and then I'm going to list it and do all that. So there's a lot of, it's a very wide range because there's lots of different types of contracts. We see a lot of wholesale. So, kind of tell me what are you guys seeing most often, or what are you most curious about? And I'm happy to focus on that.
Yeah. I mean, I guess I'm curious to know, do you see more disputes between, like you said, investors and contractors, or between investors and homeowners or sellers, or, between real estate partners like a JV? It sounds like the JV is maybe because, like you said, those two people have the same end goal, maybe can be less fierce, I guess I'll say. But do you, out of those three categories between investors and contractors, or investors and just homeowners or sellers, or JVs? Do you see more of one type than the other?
Between investors and contractors and investors and sellers, it's kind of split, at least right now. Different seasons, different times of the year, we see spike in different things. I do have a couple joint venture deals that are in litigation right now. It wasn't, unfortunately, it wasn't like a joint venture we did or anything, a contract that came to us after the fact. And, it's business partners suing each other because, well, I didn't get my money, and it's something that you don't, at the time you're entering into this with people, a lot of it is you may have a fantastic relationship with them. So people don't feel like they need to write out all the terms of how they're going to conduct business with each other. And that's where the joint venture problems will arise, especially if it's somebody that you're friends with, or, sometimes, I don't know, people don't want to push each other. It's very interesting, the comments I hear from people as to why they didn't do certain things in their contract.
Well, I'm also sure that a lot of those joint ventures, I'm not sure, but I would think a lot of the joint ventures are where somebody's managing the contractor, or maybe somebody is acting as the general contractor and takes on a money partner.
Right.
So that layers like a third issue on top. So you don't have a third party general contractor, so that partner who just put in the money is getting ticked off for that general contractor partner not performing.
Right. And, when you see when it's a money partner entering into a joint venture with somebody who is a general contractor, a lot of times, the JV is more terms of their deal about the flipping, but not necessarily a contractor's agreement about the contractor's duties and what they're going to do, because they just trust, well, you're the general contractor. And gosh, I can't tell you how many, aside from JVs, when investors will enter into contracts with contractors for rehabs, they will not verify. It kind of blows my mind, but people don't verify that somebody's licensed and bonded. And, it's very easy to do, to go on L&I's website and look it up, but it's sort of the basic things. And so a lot of the issues with contractor disputes are kind of a nightmare. And I will say this, we don't do construction law, but we work with a lot of contractor disputes just because a lot of our clients flip. And the issues, a lot of times issues will arise because people go to then list their property and they're about to close. And then all of a sudden, surprise, there's a lien on the property. And, they're a week away from closing, or maybe several days away from closing. And the frivolous lien process, so let's say it's a completely frivolous lien, or even you have a subcontractor that files a lien on your property because the GC didn't pay them. That process takes a little while. It's not a very, you have to file for hearing in court. There is a mandatory attorney's lien provision for the prevailing party. So for some reason, if your contractor wins, then you got to pay their attorney fees as well. And so a lot of times, what people I think don't realize is that anybody can file a lien on your property. It could be completely frivolous, but they can still file it, and then you would have to then fight it. And it's it gets to a point where, people want to close, they don't want to lose their buyer. And so we end up having to negotiate those for the lien release, because it's oftentimes a lot faster and cheaper than having to fight it out in court. So
wouldn't one way to deal with that would be for people to get lien releases as they pay the contractors? Yep,
exactly. That's exactly what I was going to say. That is, but you would be so surprised how many times people don't do that. And, the one thing I think investors don't know is if you go after a contractor's bond. So let's say this is shifting a little bit. If you're suing a contractor for defective work or not following through with the contract, if it's in the general contractor's bond is $12,000 in Washington, a specialty contractor like a plumber, electrician is $6,000. But if you have an investment property, you are only allowed $6,000 of that $12,000 general contractor's bond. That's all the bonding company will pay. So any remainder judgment you get against, so you win the case and you get a judgment, you're going to have to go after the contractor personally for that. So even though the general contractor's bond is $12,000, if it's an investment, you're limited to $6,000. So
Yikes.
that's,
I mean, it almost seems, again, barely even worth it.
right.
I mean,
Yeah.
considering, that covers legal bills, you know what I mean? As far as trying to go with it.
Right.
So what tips do you have for investors on their construction contracts? Are there just like, if you guys would just use lien releases, if you guys would just use, a certain clause or put a payment schedule in your contracts, right? So, or something, is there any tips that you can give our listeners? Because this doesn't just apply in Seattle. This applies everywhere, I mean,
exactly.
all across the lands of investor world, everybody runs into the same problems. I mean, I think that people these days also are that investors these days are having such a hard time getting contractors that they are putting more weight on just getting anyone, because they can't find contractors to hire. So they feel like they can't rock the boat or, have a bunch of rules in place, which is, this is how I think of things, guys. When you're running a business, and obviously, especially Joe will say, Joe's the systems guy. If we can delegate it out or create a system to not have to deal with it or have it, run on its own, that's great. But I am a strong believer in there, as an investor, or as just simply as a business owner, that there is usually, let's call it the top 3 things that you never really want to hand off, that you want to keep your eye on no matter what. I get the 4-hour work week and, being off doing something, but I also strongly believe that there are certain things that you just want to keep control of. And I imagine when you're dealing with contractors and writing up your contracts or, deciding who to work with, that there should also be, these are just non-negotiable things. These are just things that I know I have to do and get every single time, just because the downside can be such a pain in the ass and so expensive. Is there something like always get lien releases, always have a payment schedule, or always, always have a penalty for not performing? Is there anything like that? Not trying to put you on the spot, but
I was going to say, no, those are all just the 3 that you mentioned are all great terms that you want to have. So
look at that.
But there are other things that you definitely want to have. The thing with contracts is, parties are free for the most part to negotiate any terms they want. There's certain industry standards in contracts. And if there's a dispute over contract, and this is just generally speaking, the court is going to look at, what is in the contract objectively, and then they're going to look at the intent of the parties. So when you're looking at a contract and you're signing a contract, you want to make sure the contract, in simple terms, says what you mean and what you want and what you intend. And so those are, that is just generally what you want to make sure. So, for example, in a agreement with a contractor, you definitely want, execution of work. So who's furnishing, like is the contractor furnishing labor, materials, tools, all those things you want, things like that outlined. Definitely want to schedule taxes, who's paying, contractors paying any local, state, federal taxes. They're assuring that they are licensed and bonded, but you also want to do your own due diligence. Warranties are another big thing, that contractor provides certain warranties. Definitely everything you mentioned, lien releases, a payment schedule. I think it's a good idea to put meetings in there as well. This is not a requirement. These are just general terms that could be a good idea, where they keep you, if you request a meeting, then, or there could be a minimum number of meetings that you have where you meet them on site for inspections or things like that. They're keeping the property free of liens. how subcontractors are managed. I mean, the GC's in charge of making sure all of that is paid. Again, properties free of liens, that type of stuff. So there's insurance requirements. They should comply with, any of the owners' like insurance requirements. So really, it's just there's general terms that are a good idea, and I think you mentioned some of them. There are
and outside of contracts, guys, just getting references also, right? I mean,
definitely.
Getting references or, looking at their past jobs and things like that,
Well, and you just you can go references. Yeah, definitely references. And even just making sure you look them up on L&I's website, because it will tell you if there's lawsuits that they've had and what's pending and the status of their licenses. I had a situation where I had a client who had, it was a 7-figure house built, and the builder's license was suspended the entire time. And there was all these defects with the property, and we ended up suing. We got a judgment. We recorded a lien against the builders, another piece of land that the builder owned that they were going to build on. And so our lien was pending. And what we've seen, this is kind of a caveat, it doesn't happen often, but we've seen it happen more often, is builder then built on that property and sold that home with our lien still on it. It went through title and escrow, and what escrow did was they closed anyways, and they did a escrow holdback for the amount of our lien. And it just blows my mind, because typically you think, I have a properly recorded lien against this property, and your liens usually get paid out prior to closing. So what we've seen, and this is small and large escrow companies, and this has happened probably 4 or 5 times this year already, where we've been seeing these escrow, it's crazy. These escrow holdbacks where, they'll have the seller sign a personal guarantee and indemnify the buyer and basically say, if this lien holder sues, we will go ahead and we'll indemnify you, we'll take care of everything. But what it does is for the lien holder, so for us in this case, it takes away some of your power, because now the property's been sold, and now you've got, this contractor who we have the lien against. They're negotiating to try to resolve it and not pay as much, and to then enforce it and have to go through court. It's long and it's expensive. So this whole escrow holdback thing is really bothers me, but I think that's a different episode.
Wow, that's scary. That's a little bit scary.
Yeah, it is. It really makes us mad as attorneys when we see that. But
how do you protect around that? Just make sure that I don't know. How do you protect around that? I don't know.
Well,
that's another topic.
That's another, I don't have a good answer to that either, because you think once you have it properly recorded in the county and everything, and it's on title, it's on the title report when they pull it, and they still choose, escrow still will do a holdback in that amount and keep that money until parties resolve. And at some point, and I'm sure it gets interpleaded. But that's one thing we haven't really, and we're just still trying to, figure out what gives them even the authority to do this. And it's really because they have the, maybe your title and escrow guy can answer this, because that might be a good question for them, because I've left some more information on that, because it does make things harder for people to have proper liens on properties that think, hey, if this person ever goes to sell, I'm going to get paid out. So it's interesting. But the terms you mentioned for contractor agreements and just some of the general terms I've mentioned, it's good. The one big thing for anytime there's any modifications, you want to make sure, and changes, you want to make sure you get that in writing. A lot of times people won't. What I've seen is I had a client who has an apartment building, and they entered into, a 6-figure roof replacement just on a 1-page bid. And that's what the contract was. And then all these modifications happened along the way that were just oral. And then all of a sudden they get a bill that's so much more than what they contracted for. So it's simple things like that that will really protect you. Don't think just because, I have a good relationship with this person, I don't need to, have these things in writing.
Right. Right. I always think that there should be, I mean, maybe people have this out there, like a checklist of, these are the non-negotiable items and these are the items that you go for and you see if you can get it, right? Kind of I don't want to call them a wish list, but the add-ons,
Right.
And these are the other admin follow-up items if this happens. I mean, it seems like something like that should be floated out there somewhere. Maybe you guys all have that. If you do, let us know. Share it with us because we like sharing.
Yeah.
Seattle Investors Club. Well, geez.
Well,
how about this? What about calls from from investors or brokers on earnest money deposit issues and stuff like that? Do you get any of those calls?
We do. Surprisingly, a little bit more this year than last year. And, with real estate contracts, before I just get into the earnest money disputes, I was just going to say with real estate contracts, you've got obviously your MLS forms, and then people like to use their own contract wholesalers particularly, or other people, because sometimes they think, well, the MLS forms are way too complicated and I've got a seller who just going to confuse them, and so they want to use their own simplified
Well,
version.
if you're not a member of the MLS, if you're not an agent who's wholesaling, you can't use those forms anyway.
You can't, although I am surprised how many people still do.
I hear that.
There's, yeah. So there are for wholesalers, there's a lot of times I will see their own contracts, but just in general, real estate contracts, of course, the things you want to make sure that are included are like things like your legal description boundary, just make sure there's an accurate legal tax parcel. Without that, you don't have an enforceable contract. And that would apply for even one thing I'll point out is lease agreements. So if your lease agreement is over a year, you want to, for a landlord-tenant situation, you want to make sure it's a notarized lease and you want to attach a legal to that. So a lot of people don't know that, because if it's not notarized, then it becomes a month-to-month lease after like
over 12
period.
months, right?
Right. Yeah.
So if you're signing
exactly.
an 18-month lease, so what if it's just an apartment? Let's say you own a 10-unit apartment building, and in one of the units you sign an 18-month lease. You're going to use the legal description for the entire property on that?
You would use the legal. Yeah, you can use the legal for that. There's usually a specific, each unit usually has some sort of, specifier, like there's a unit, but you can use that. You can use the legal description for that.
Let me back up.
You want to make sure it's accurate.
Yeah, let me back up for a second. We're talking about how, like in real estate contracts, you really don't even have an enforceable contract unless you have a legal description as part of that contract. We all agree with that. Is there anything in construction in contracts, like contractor, general contractor contracts between investors and their GCs, that is in the same light? I guess I'll say that, like you need, how we need legal descriptions for real estate contracts. In construction contracts, is there anything that absolutely has to be there or it's not enforceable?
No, there isn't for construction that I know of. There isn't, but I always think that it's a good idea to put in what specific property it is as detailed as possible, which is the legal description that the contractor is performing the work on.
So it's not a requirement by law. It's just a best practices.
It's good practice to have that. There is, specific things like in real estate, you've got your seller disclosures that are state law requires it. And of course, the buyer can waive that form, the Form 17. But, if answers to any of the environmental sections is yes, then they can't waive that. So there's certain things like that. There's very specific scenarios. There's 7 specific scenarios, I believe, in the RCW where the seller disclosure is not required. In real estate contracts, for example, in particular, you can have a specific performance clause that's not allowed in every single contract, but the courts, basically what a specific performance clause is as a buyer, you would want that in there because then the court can force the seller and order a seller to complete the sale. if a seller defaults according to your agreement. So there's certain little things. I like to add non-merger, or sometimes it's called the entire agreement clauses, which basically says nothing, no other, oral agreements or other agreements outside of this contract are enforceable unless the parties actually agree in writing to amend a certain term. So I think that's always a good one to have, especially when you're working with contractors, and just even in real estate. I will also add an independent attorney review clause in most contracts. I do, actually in all of them, where especially when you're dealing with like wholesalers a lot of times and investors when they're buying, you want to make sure, especially if you're dealing with more of a vulnerable type of seller, that you have that clause in there and you give them the opportunity. They may not choose to exercise that option, but you at least want to make it that it's in there. They've initialed it and acknowledged it, that they have the opportunity to have this agreement reviewed by an independent attorney. So there's never any argument about, oh, well, I was forced to sign this, or I had no idea what I was signing, things like that.
That's a good tip, guys. So what's the name of that clause? An independent attorney review?
Yeah, an independent attorney review clause.
That's
basically
good.
You're giving them the option to have it reviewed. So
I think in general, investors are so nervous that, well, if I offer this, it gives people an out, or it gives, the truth of the matter is when somebody wants to sell their home and they are a motivated seller, when they want to sell, they want to sell. Rarely does it ever happen, I think, where anything, if you should just disclose everything and give them every benefit and be as on the up and up with all these sellers. That wholesalers need to do this in general, because if you do that, they don't care. They only care when you try and cheat them, when you try and pull the wool over their eyes. But if you tell them and you're honest with them about your intentions and that you're an investor, that you need to make a profit, that you encourage them to get an attorney, that, yep, you're a broker too, all these things, it's a big myth that scares off sellers who are motivated sellers for investors, who investors want to work with. It's a myth that scares them off. I think it is actually the opposite. I think that the more upfront and clauses like that are to their benefit makes them more comfortable and shows them that you're not, some skeezer trying to skim their equity or whatever.
Right. No, I 100% agree with that. And you'd be surprised as to, when we try to add some of these clauses, we get pushback from some of our clients because the concern is, well, this will scare off the seller, or this, or whatever. They think they're going to back out of the deal. Well, really, we've seen so many cases where it's dealing with, somebody saying, a seller who's not really educated in the industry or these terms, oh, I had no idea what I was doing. I was, scammed, this and that. And so it's really to protect you, and it's to protect them as well, and it's to try to avoid future issues. So
I think you just hit it on the head, is they think that it's to protect them, the sellers, but it's really to protect you, wholesalers. It protects you. And if something is borderline where you may or may not be getting that deal, or you got to sneak it through, then you probably need to be overly cautious anyway, because you don't want somebody coming back at you. I'd rather lose a deal than slip it by somebody, right? I want to sleep at night, right? The mimosas that I drink during the mornings with my mom friends don't always, help me sleep at night, I guess is what I'm saying. I need to want to live on the up and up here so I can sleep at night, no problem, right?
I can't wait till September till I can have a mimosa.
Well, you won't be sleeping much come September.
No, I won't.
You might want to
these issues, what we're talking about, this is why there's certain laws that have been put in place. So, the Distressed Homeowner Act, that was, what's the name of the actual act? It's the Distressed Home Consulting Act. That was put into place, I think, back in 2008, but that was because of equity skimming and scams and things like that. So you have to be very careful, especially with wholesalers. But even as agents, that act is a fairly complex, and it's confusing, but it applies to, people, a distressed home. So it's a personal residence. So it's not somebody's investment properties. They're personal residence that's basically in danger of foreclosure. And that's because, they are behind on their mortgage or tax payments, things like that. So a person there's very specific requirements where a person could be considered a distressed home consultant. And it's very important. It's probably more time than we have today to go into it. But, if you, for example, one of the things, if you're helping someone stop or postpone the sale, or you're buying their home within 20 days of a foreclosure sale, or this one is an important one, you're entering into an agreement to buy a home, and then you're letting them stay in the property. Because let's say they need additional time to move. You're letting them stay in the property for more than 20 days beyond the closing date. Then you can be considered a distressed home consultant, whether you're an agent or not. And so then you have fiduciary duties, which is one of the highest standards of duties you have, to the seller. And so that's one thing I think it's good for people to be aware. The specific RCW about that is 621-34050. And it's important to know when you can and can't be considered that, because I have seen wholesalers use these agreements where they have these distressed home consultant. There's a notice that's required by law, but they're not dealing with distressed properties, but it's just, an agreement they got from a buddy or something. And it's like, okay, well, this shouldn't be in here, because the impact of this is, there could be criminal and civil penalties to it. So it's something you just want to be really aware of. And yeah.
What if the seller is represented by an attorney on their end? Because that's when
they're exempt if they're represented by an attorney or a licensed agent, and their home's going into foreclosure. Then you're fine. In that case, that's an exemption.
Right.
Yeah.
So let me ask you a question. Can investors who are listening to this today, if they run into hopefully none of you are mailing to or doing any mail or direct mail to distressed homeowners, because that's a no-no. So if you're doing that, stop it right now. But in general, it's very plausible in general when you're going about your business that you're going to run into a distressed homeowner from time to time, even if you're not trying to target them. As an investor, would it be advisable for them to say, hey, I'm interested in purchasing your home, but you need to have representation in order for me to do that? You could pay that seller's legal bill, right?
Yeah. You could agree. You'd want to make sure there's, certain types of agreements in place that, but you could certainly do that, because you want to make sure it doesn't seem like, okay, you're paying their legal bills and having any influence on,
right. I got you.
Representing them.
Or maybe you could increase the purchase price by the amount of the legal bill or whatever you would do.
Right.
But I guess what I'm saying is, hey guys, if you run into a foreclosure house, why don't you refer the seller over to Synthia and have her represent the seller? Is that far reaching what I'm saying, or not?
Yeah, it's not far reaching. I will tell you, typically there are other attorneys that deal with this. We typically don't. We do a lot of post foreclosure type work more than pre foreclosure.
Yeah.
And so it would just, I know we've done it before, but we'd have to have very clear disclosures as to, the person who is then referring us knows that they are not our client. We don't have their best interests at heart. We have the seller's best interest. But all that is possible, me or other attorneys. But it is a good idea, because yes, that takes you out of this distressed home consultant issue. So it is, I always think it's better when you've got people, because people, I think,
or insert a broker. Just insert a broker.
Exactly.
But you can pay can the buyer then? Most buyers, I would say, don't need a buyer's agent. Investor buyers, they don't need a buyer's agent if they come across a property, right? So let's say off-market property or something. Let's say you come across that situation and you're like, well, go find a broker, or here's a list of a few brokers. I don't know if you want to do it that way or if that's bad, that they can represent you and I'll be the buyer, and then that buyer can pay the commission. Is that legit?
Right. Yeah, you could do that.
Right. And it gets around the risk, right?
Right. Exactly. And so, one of the things is when you're doing business is when you're buying properties from sellers if you're buying their investment property, this doesn't apply. This is only on their home, but it's just really about being a decent, good person and wanting to do the right thing. Like, I get everybody is in this because they want the deal. And it's great. You want the deal, but you also want to make sure it doesn't come back to bite you later because you decided, okay, I'm going to hide the ball on this and that. And, I will say this, there's certain scenarios, like when it comes to inspections and things, for a buyer, like Washington is buyer beware. So those things you want to know about. It doesn't necessarily apply so much in maybe some of these investment type deals where you're just buying as is and you don't care.
A buyer can't rely on the Form 17 so much, right, anymore, because there's been court cases. Exactly.
Oh, yeah. Oh, gosh, there's been court cases where the seller has even, hit the ball and tried to conceal defects. And the court still said, nope, buyer, if you're represented by an agent, you did an inspection, you have this duty, you're responsible. And we've actually won on several where our, seller's agent got sued and the brokerage got sued, and we've won on summary judgment because it is a buyer beware type of scenario. So there's lots of,
we could go on forever like this, guys. Let's talk about for a second. Let's jump to tenant landlord stuff. What are the toughest types of evictions that you see investors deal with? And we'll end it on that note if we jump into that, because of the excitement these days about buy and holds. We know that evictions, sometimes, guys, I think you can get a better deal buying a property that has an existing tenant in it and dealing with that and underwriting those numbers into the deal and taking on that extra risk is a good potential way of getting deals, because a lot of landlords are like, I just don't want to deal with it anymore, right? Once it becomes vacant, then they have no reason not to list it or get top dollar. But to walk away, especially with a tenant that is in a lease that has several months left on it, can be a great opportunity. But let me ask you one thing about this. Is a technicality that I'm not so sure I know about 100%, but I'm going to throw it out there. If you're in the city of Seattle, maybe it's only city of Seattle, and you are buying a property that has a month-to-month tenant, okay, and you want to give that tenant notice to vacate, and they have a month-to-month lease, so your brain might go, I only need to give them a 20-day notice or whatever the notice period is. I'm not sure. You can confirm things.
Yeah, you cannot do that in
rule. Is there something significant about a month-to-month lease that doesn't really give you just the month?
Yep. So, month-to-month leases in general, outside of City of Seattle, this is the one thing that people get hung up on a lot, is they think, okay, I just have to give them a 20-day notice to vacate. And so what they'll do is, let's say, you want to end the lease term end of May, and it's May 1st. So they'll give a notice saying, your tenancy is terminated on May 20th, because that's 20 days. From when I gave you the notice. And that's not correct. It's actually, you have to give them till the end of that monthly rental period. And the name itself is confusing because you are required to give them that notice 20 days before the end of that monthly rental period.
Well, anytime during, let's say, the first 10 days.
The first 10 days, exactly. If you are mailing, if you can't personally serve and you're mailing the notice, you want to make sure you leave enough time for mailing. So typically it's one extra day for mailing. So you want to make sure you give it. I always say give it during the first 5 days of the month, just to be sure, and make sure you give them till the end of the month. However, the caveat is a lot of things are different in Seattle. Seattle does not allow you to terminate a month-to-month tenancy with a 20-day notice. Seattle specifically has something called a just cause ordinance where there's, like 22 reasons where you can terminate a tenancy. So if you as an investor are buying a property, REO, however you buy it, you are inheriting the tenant and whatever lease terms they had with the previous owner. The only exception to that rule, even in Seattle, is if you buy a property at auction, at a trust, and I shouldn't say auction, if you buy it at a trustee sale and you have a trustee's deed. That's the only exception, because that's where the 60 and the 90-day rule come in.
And this is the new 90-day rule. This is where the new...
So it gets a little confusing. Washington has a 60-day rule that applies where if you buy a property at a trustee sale, the tenant has 60 days or more till the end of that monthly rental period to vacate. You have to give them proper notice, of course. And then you don't have to keep them as a tenant. The 90-day rule applies to all foreclosed properties. So regardless of how you buy it, if you bought it and it's a foreclosed property, the 90-day rule applies. And so unless, though, you get a tenant that's on a term lease, then they have to stay in the property. Then they can stay in the property during that term of the lease if you're not moving into the property. So this is why you sort of need, you need an attorney on your side to help interpret these things, because how the 90 days applies in Seattle is going to be interesting, because it usually under the 90-day law, if a tenant is on a month-to-month lease, they still get their minimum 90 days, but then they can leave. But if they're on a term lease, they can't. But in Seattle, you can't terminate a month-to-month lease. So you've got federal laws, state, city laws, local laws. So it can be kind of a lot to interpret.
What if nobody can find the lease? What if nobody can produce a written lease?
Then they can't produce a written lease, then it's presumed it's a month-to-month lease.
Geez, a lot to know, guys, here. I mean, literally, whenever you're thinking about buying a buy and hold property that has a tenant in there, whether you're a wholesaler or, even at auction, you have a heads up. You should get with your attorney, AKA Synthia, maybe, right? And you should, if you're in the Seattle area, do you only practice law in Washington? Synthia?
Yes, I'm only licensed in Washington. I will say this, for, people who buy at auction and stuff, we actually do have notices on our website. We have a landlord-tenant library, and we have notices that we've provided for free with instructions that people can use. We don't, of course, guarantee them if they decide to delete things or change it up, but I'm more than happy if they call us to sort of chat about what the proper notice is, because the main thing with evictions you have to know is if you don't send the initial notice properly and you try to evict someone, your case is going to get thrown out. So sending the right notice and serving it properly is the most important component of any eviction case.
So why anybody would try and do this on their own, right, is beyond me. I think for me, I'd be like, okay, here's the deal. Give me essentially the menu of the checklist on this particular situation, on this particular deal, how I need to proceed. Because what if it's even, is it even get more complicated if it's a HUD tenant or or something like that, or not?
Typically
Section
it
8?
doesn't.
Okay.
Section 8, no. A lot of times with Section 8, when you're evicting, we just try to work with their Section 8 person, whoever is there. I'm forgetting the term, but they're assigned person. We'll try to work with them, because here's the thing. A tenant can lose their Section 8 benefits if they're evicted. And so a lot of times it's faster and quicker to work with Section 8 to just place them somewhere else. But you still need to issue the proper notices.
Right. And it's the right thing to do. So,
yeah.
Wow. Yeah. Well, that was a lot, guys. That's a lot. I mean, I would say that is all good info. That my thoughts on this is that, boy, I'm gonna run it by my attorney before I, just for peace of mind. I mean, it's not that, it's way less expensive to deal with having a quick review or making a quick game plan ahead of time than having to deal with stuff after the fact, guys. And if you're penny pinching, a lot of investors are such cheap asses. I'm sorry, guys. You guys like step over, you guys need to snap out of it and understand that there are certain things that, you need to do from the start. And maybe that one of those things is making sure that whenever you're dealing with a tenant situation, running it by your attorney on the game plan real quick, or even your property manager. I don't know, but I don't know the difference between, you got to know that property manager is up to snuff. That's for sure. So,
right. And we do, we review and draft property management agreements and things like that for landlords. We also work with property management companies, but it's one of those things where you're basically, you're spending upfront to basically protect yourself and prepare yourself. So hopefully in the future, you don't have to spend way more, and then the time and the stress associated with it, and of course the money. So I know we chatted about a lot of stuff. I didn't even get to touch on the earnest money disputes, which we do see. I'm surprised at how much more common it is, but we do see a lot of those, with agents and things like that. And with that, I always just I encourage people to try to resolve it out of court, because with earnest money disputes, escrow only holds it for generally 30 days, and then it's interpleaded, and then you got to battle it out in court. And sometimes the amount in dispute is not worth the amount spending on attorney fees and court fees.
What's the number one thing you see earnest money disputes about? Like, these, whether it should have been released or not, or if somebody gets it back or not. I mean, these days what's happening. Exactly.
It's around financing. It's usually related to the financing contingency, and, sale fails to close because buyer wasn't able to get financing. We see a lot of those, and as long as the buyer did not expressly leave the financing contingency, it does survive closing, and they are entitled to the earnest money. So there's all these things we could go into about, for the Form 22 AR and things like that. But
right.
I would say the most common is it's related to financing. And then here's what people don't get is once, escrow interpleads, you've got court filing fees. So $240 is taken out, $240 is taken out for court filing fee. You've got their attorney's fees, which can vary. Sometimes the contract limits it, but it can vary as to what the attorney's fees are. So by the time you get your earnest money back, you are not only paying some fees, you're paying on your attorney's fees, and you might not even get half of what was in there. So it just really is, I really try to encourage parties to try to resolve it out of court. And that's what we do in most of these situations.
Right. Hot topics for sure. So much more to talk about. So we'll have you back on. I know we're going to plan for you to come in person to Seattle Investors Club and dive deeper into these topics also. So you guys look for that this year, that Synthia will come, right? Putting you on the spot.
Yeah.
Okay. That's right.
Yeah,
Joe will hold the new baby while you're giving your presentation. Joe, the baby whisperer.
Yeah, I've had that job before.
All right, Joe. Counting on you. Well, thank you guys so much.
Yeah, thanks for coming on and taking the time. We know how busy you are. And we look forward to hearing regular updates from you. And again, where's your website that people can go look it up and look all your forms and stuff like that?
So it's dimensionlaw.com, dimensionlaw.com.
Okay. And your contact information, they can reach you through your website. That's Synthia Melton, guys. Right?
Yeah, so my phone number is on there, and my email is actually on there as well. And my name is Synthia with an S, so a lot of people get confused by that. But all our contact information for our attorneys are there, and you can even contact us through our website. But yeah, I hope this information is somewhat helpful to your members.
For sure. Joe, are we going to drop a link to her website on the podcast notes?
Heck yeah. Anybody who's driving, we don't want you to be, typing things into your phone as you're driving, because a lot of people are listening while they're driving. Make sure you go to seattleinvestorsclub.com/36. That's seattleinvestorsclub.com/36. You can get all the show notes, everything that we've talked about today, including Cynthia's contact information.
Awesome. Well, good stuff. Well, Claudette, I'm always hungry at the end of these podcasts because it's about 12:30. And Claudette,
Right.
who is on our team, is an excellent cook. And she dropped off for me when she was picking up some open house signs from me today, a nice lunch of homemade Caribbean food.
What?
Oh, that sounds amazing.
Hello. Yeah. Although we all love bongos, what's up to our friend Matt Smith over at Bongos? But today I'm eating the homegrown Caribbean. So,
Wow.
yep, it's a miracle I've been focused this long. Let's put it that way.
All right, guys. Well, thank you so much. So I will, Joe, I'll look out for your email and I'll send you whatever information you need. And then, yeah, I know that was a lot. I feel like we didn't
We're
cover
still
some of
on.
the
We're
stuff,
still
but-
on. Hey, everybody. Yeah, we're still talking. Hey, you guys, we're just now. This is how we roll. We're going to talk about our weekend plans here too. You guys can all stay on with us if you want. But we're still recording this, I think, right?
Oh, yeah.
Oh yeah.
Oh, okay.
So good thing you
Okay.
didn't tell that dirty joke that you were.
Right.
Woo! All right, Joe, wrap us up, and then we can listen to all Cynthia's jokes.
Cool. Yeah, thanks, guys. If anybody wants to give us a review, we'd love it. Head over to seattleinvestorsclub.com/iTunes. And you too, I will talk to you all soon.
Awesome sauce. Talk to you guys later.
Thanks for listening to the Seattle Investors Club podcast. If you have questions that you'd like to have answered on the show, shoot us an email at info@seattleinvestorsclub.com. Now go out, take that action, and build that real estate business. Thanks for listening.